So just to do a quick introduction of what civil asset forfeiture is, for those of you who have not read all of our reporting. It is a tool, it's a common tool that law enforcement can use to seize and keep property they think they link to criminal activity, which is often buying or selling drugs, but not exclusively that. It's a civil case where in Texas, the prosecution sues the property itself, not the person who possesses it. And because of this, it's in civil court, there's no right to an attorney, it's completely unconnected from any potential criminal charges, which sometimes there are no coinciding criminal charges at all. It's a common practice, and it's fairly controversial. It's gained criticism over the years on both sides of the political spectrum, from people who claim it gives too much power to police and has a financial incentive for law enforcement. And it has been more restricted in different states throughout the country in the last few years. But it's a tool that law enforcement argues is an essential tool for policing and to take away ill-gotten gains from criminals. So we'll get to how law enforcement kind of uses this property and how they spend it, and kind of get into the changes to the law, reform efforts, unsuccessful efforts. But I'd like to start by just kind of giving a clear picture of what police seizures are here in Texas. So can Ms. Beavers and Representative Canales, can you kind of give some examples working kind of on both different sides of this issue of what are some kinds of cases that you see here where you're using civil asset forfeiture or where you are arguing against it?
The majority of our cases are related to drug dealing. I mean, the drug trafficking industry is a huge multi-billion-dollar moneymaker for cartels. So that is the primary, or the majority of our cases are from drug dealers. I have to say, like Jolie said, I've been 19 of my 23 years with the Harris County District Attorney's Office has been in the asset forfeiture division. So I've seen how it is an essential and integral tool in the whole criminal justice system. Unfortunately, there has been some, I believe, maybe rhetoric or a false narrative that has gotten out there by special interest groups. And unfortunately, law enforcement has not done a very good job of getting out the truth about asset forfeiture. So I'm excited to be here today to be able to talk about the truth of asset forfeiture.
Thank you. I apologize for my voice. I've got a little Austin allergy, but I do want to hear the truth because in my practice, I see a lot of abuse. I see it throughout the state. I can tell you that they say it's a tool. I think sometimes it's just a weapon. A weapon. Okay. And sometimes I've seen cases that would just blow your mind. And the standard of proof that the state has to prove to take your property is the lowest burden of proof in the legal system. The standard of proof, which is a preponderance, the standard of proof to actually seize it's even lower. It's probable cause. And so there doesn't have to be an underlying criminal offense, as you mentioned. There has to be no conviction. Oftentimes the state has the resources and power to detain your property longer than what it's worth to fight for it. It has become I think it can be a tool, and I think it's got its place in American jurisprudence. I do. But I think that what you've seen is the proliferation of its abuse, and we need reporting requirements. We need to see what people are doing. I think there are some counties that are doing a great job. I think there are lots of counties that are doing a bad job. I'll give you the best example is Jim Wells County. The DA at the time was named Joe Frank Garza, got sentenced to prison for spending over $3 million, I believe, in cachada, gambling, because there was no reporting requirements, there was no oversight. And so the officers and prosecutors and police departments and law enforcement know that this is a way to subsidize their departments. It is. There's just no question. They buy things. They buy cars. They buy weapons. There's all sorts of things that the statute's broad. And so while I think there is some good, there's a whole heck of a lot of bad.
Do you have any specific examples of if cases are closed, like cases that you've seen specifically as an attorney or as just someone who's come to you as
I had a case not long ago that we won in trial where the son of a mother and a father who lived at their house, he was outside, he was dealing. Okay? They went in their home, took everything they owned. And we had to fight for it. Some people are old school and they don't like to use banks. They keep their money. They seized everything they owned. I was a bus driver. She was a teacher. Of course, the son was up to no good. That doesn't mean you seize everything in the people's house. I recently represented a man, probably about 2 years ago, where there had been a shootout down the street. Somebody blamed them in their house. Went inside. They took from his wife's shoes, the the televisions off the walls, a motorcycle, a pickup truck, everything. And it's just it just blows my mind the level at which. And I'm not saying that they're doing that in Houston, but I can tell you that there's a lot of places where there's a hunger for money, and they need it. And so I can tell you that like I said, there are good actors. But the law is ripe for abuse because of the lack of reporting requirements, because of the lack of burden of proof, because of the lack of a criminal conviction, and on and on. The Supreme Court is laid into them. Justice Willett recently did too. I think that the bottom line is I think that without question, reform we're in desperate need of it.
Well, if I could respond to all that. It's been my experience, law enforcement is not interested in seizing innocent people's property or trampling on their property rights. That's just not the case. What law enforcement is interested in is seizing property from criminals, from drug dealers, contraband from criminals, from human traffickers, that kind of thing. And in 2011, there were reforms. Senator John Whitmire led the charge for reforms of the asset forfeiture law, Chapter 59 of the Code of Criminal Procedure. And in those reforms, we do have reporting requirements. We get audited every single year. Also, within Chapter 59, contrary to what special interest groups say, there are protections for due process, to protect the civil liberties of citizens. And to follow the Constitution, okay? There are penalties for any kind of abuse. And whenever you hear these instances, these anecdotes, take a look at them. Take a close look at them. Don't believe what you read because there's always more to it than you're seeing, okay? And there's always another side of the law. So, we're here to tell you the truth. And unfortunately, law enforcement has not done a very good job of getting what actually happens out there. If I look into this instance that Representative Canales is saying, just like I've looked into a lot of things, these anecdotal evidence examples, I could tell you the whole truth to it. And it's not just we're going in there and doing a money grab. We're just not interested in that. In the past decade, since the reforms, there has been no reportable, or that I've seen, systemic abuses with asset forfeiture. All you're going to hear is anecdotes, okay? And let me give you one example that I've seen that is just a blatant example that does not tell the truth. There is a case that goes around that's thrown out there still. It's called El Ali. Okay, Institute of Justice loves to put this out there. And it's the way it's portrayed is that law enforcement seized an innocent owner's vehicle. Okay, that's the way it's portrayed. And you can see, go on their website, that's the way it's portrayed. But the truth is, and it was in Harris County, let me give you, and I want to give you the cause number so you can go look at the truth. 2009-52869. And what happened is that Mr. El Ali said he was an innocent owner, but the truth is that the driver of the vehicle, Mr. Faustino, had 8 prior DWIs, okay? On this instance, he was driving drunk, almost hit a police officer, evaded. When they stopped him, he had cocaine in the vehicle. So, of course, we're gonna take that deadly weapon away from Mr. Faustino, especially after 8 prior DWIs, right? So it turns out that Mr. El Ali was only a title holder. He had sold this vehicle 5 years prior to Mr. Faustino. And Mr. Faustino, turns out during discovery, had made every single payment. So he wasn't an owner. He wasn't even an innocent owner. And even in the pleadings, he abandoned his innocent owner claim. So when you hear this, when you see what this false narrative that's put out there, please take a chance and look at the facts. Look at what's truly out there. We don't have the huge budget that maybe Institute for Justice. We don't have the $88 million budget to put that out there. But I'm just hoping we can get to the truth today about what happens with this tool.
So I kind of want to jump in there, and you've been getting law enforcement having issues getting their side out, and we've been talking about reporting, and I want to tie Jacob in here as well. So reporting is one of the things that we've been looking at the most. There is a lack of reporting on the front end of what is seized, how often it's tied to a criminal charge, just kind of giving a clear picture of how this is used here in Texas. In Kentucky, it seems to be kind of flipped because we actually, since 2011, have to report, law enforcement agencies have to report how they spend forfeiture money. And in Kentucky, it's the opposite where, can you explain a little bit how the laws are there?
So in Kentucky, law enforcement agencies are required by statute to report what they seize every year and report that to our Justice Cabinet. And that's just, they're required, every agency that seizes property is required to send a report. There's a form supposed to detail every seizure, whether it be cash, property, guns, vehicles, what have you, and send it to the Justice Cabinet, and they are to, kind of compile this and keep that. In our reporting with the Pulitzer Center, we found that few agencies really do that. We looked at 5 years of data for law enforcement agencies, about 330 law enforcement agencies in the state, and found that in those 5 years, only 11% of the law enforcement agencies reported as they were required to every year. So that's not, some agencies would report 1 year, then not the next, and then the other year. So there was sporadic reporting, but there was not the required reporting. And so that kind of leaves this gap of, we didn't really know what was truly being taken. And in those 5 years of those agencies that did report, there was $36 million reported seized. And so there could be much more if all the agencies did follow the law. And there's been efforts to enforce that. But those efforts, they haven't. There was one bill filed last legislative session that was withdrawn before it got a hearing in committee. And the sponsor of that bill said that was more just of a conversation starter. We just kind of want to get law enforcement agencies kind of to the table to talk about what can we do so you all can begin to report as you're required to do.
So,
that's not what happens here.
Well, so in
Texas.
Well, that's just an understanding. It's just to talk about how it happens elsewhere, yeah. But there, like you said, there is no requirement to say how you spend, though, and so that is a great void, and we have tried to report on that. And Kentucky, such as Texas, probably there are very small counties with very limited budgets, and that means some of the receipts are handwritten, some of the receipts are difficult to find, and so to track that down is even more difficult.
And so you talk about this false narrative or law enforcement not being able to get their side out, but there has been some proposed legislation in the last few years to increase reporting requirements here in Texas, which would include things like what I said, detailing how this tool is used and what is seized in each case and tied criminal charges. But there's been steady resistance to that from law enforcement. And so can you explain a little bit trying to get this story out, if trying to get the truth out, transparency seems like, a reporting would help, which is what we tried to do in our story. So can you explain and maybe some push for this and why there's some resistance to something like that?
Sure. Well, I'm all for transparency because I want to get the truth out there. So, and that's why we worked real close with you, Jolie, on making sure that we got the statistics to her. We spent a lot of time on the phone talking about the intricacies of asset forfeiture. Right now, law enforcement remember this, does have to report every single year their stats to the Attorney General's office, okay? Plus, we get audited every year as well. So the information is out there. Now, what we're talking about is something that could be covered by the Freedom of Information Act. If you ever wanted to, without us voluntarily giving you our stats, you could go and do a Freedom of Information Act. I think that what law enforcement is concerned with is let's not burden them too much on trying to provide intricate details. We're already doing a lot of that. And if you want, there's avenues for you to use, a Freedom of Information Act. Call up and ask, can you give me these stats? And I a lot of times people will, the law enforcement will. So I think the resistance is probably just, hey man, we're just trying to do our job out there. We're just trying to fight crime. And then we're, having to do all this. And some of these smaller jurisdictions, it might be, onerous for them to do that. Luckily in Harris County, we have the programs, computer programs, we have the data. But I think that's more of the resistance. I don't think it's a major resistance. I think it's just like, gosh, we're doing all this reporting anyway.
And to clarify, what is reported now is like spending, like here's how much we forfeited, and the difference between seizure and forfeited is you seize the property at the time, and then it goes through the court process and then can be forfeited over to law enforcement, and it's usually split. It depends on each, jurisdiction, but generally around like a 70% goes to the law enforcement agency and 30% goes to the prosecutor. Is that like a general?
That's kind of a general local agreement. Each jurisdiction might be a little bit different, but yeah, law enforcement under Chapter 59 can seize contraband, not property. What's contraband? Any property that is used in, intended to be used in, or the proceeds of a felony criminal offense, okay? That's the burden that we have to go under. It's not any property, as a lot of special interest groups want to try to tell you. So we have that burden that we have to adhere to.
So do you want to go ahead and talk about the reporting?
I just want to address the point, the burden. She says they have a burden to prove. The burden isn't much of a burden at all. I did want to comment to some of the comments that were made. It seems strange to me that when the state says it's the truth. When somebody else says it's an anecdote. These aren't anecdotes. The reality is there is a great potential for abuse. To deny that is absurd. To deny it's disingenuous. We've seen it throughout the state. So when you talk about reporting, you're right. Every effort that's been made has been met with a full front force by the state and by law enforcement to thwart any more reporting. If you want transparency, accept transparency. That's the reality of it. Going back, you don't have to have one conviction. They don't have to charge you with a crime. And here's the most offensive part is that after they've taken your property, you've got to go hire a lawyer. What if you're indigent? State doesn't provide indigent lawyers. It's a civil case. So what if you're indigent? That's your only car. They took it. By the time you get your car back, the storage fees that the state doesn't, let's say you win your case. You win your case. They took your only car. By the time you can win your case, the storage fees for that car, the car's not even worth it. So you have to hire a lawyer. Your property's already gone. Most of what they collect, they just took it by virtue of the fact they can take it. They took it because nobody's can fight for it. It's not worth fighting for it. And so I can tell you, and I'll once again say there are good actors, but there's bad actors. They are policing for profit. It's a fact. And to say any other thing, I'll let you finish, ma'am. So the reality is this. Texas and the citizens of Texas deserve better. We deserve to know exactly what law enforcement is doing. We deserve a process that's fair. And we deserve a process that if the state takes your property and took it and loses and wrongfully was judicially decided that it was wrongfully taken from you. Here's an even more offensive part. There's a fruit of the poisonous tree. If the evidence that they took from you was illegally seized under the law, it doesn't matter. It doesn't matter. The Supreme Court of Texas, like they usually do in Boeing, and I think this was Lincoln Navigator, they said it doesn't matter. They can even legally seize your property and they get to still keep it if you can't meet your burden. It just seems that the deck is stacked, and it's stacked against Texans like me, and you, and her. It's stacked. And the fact of the matter is you better either have the money to hire a lawyer, you better have the money to to be able to withstand the wherewithal or have the wherewithal to get your car out of the lot. But at the end of the day, the state can lose. The state never loses. They don't have any incentive not to seize your property. Their incentive is to seize your property. Everything is in the state's favor.
This is what is offensive, is that this is out there that police officers have a financial incentive, a perverse financial incentive, okay? This is what you hear. They're policing, that's the infamous policing for profit, that they're highway robbers, okay? That they have this perverse financial incentive to go out there. I can tell you from my experience what is happening is that police officers are not interested in that. You could say anybody, let's turn this around, has a perverse financial incentive, okay? For example, a special interest group, maybe the Institute for Justice, they have a perverse financial interest to maybe report the system as being broken, okay? Report, because of course, you know, that is what brings in your donors, right? So if of course a story doesn't come out there that, oh yeah, nobody's gonna donate to a cause that says, yes, you know, the system is working just fine, okay? So why don't we, because they have a perverse financial interest, why don't we, instead of their lawyers making $300,000, $400,000, $500,000 a year, why don't we have them make what a public servant makes? Okay, we're not gonna say that. Why do we get to say that for police officers? Why in the world do we say that's what those hardworking, low-paid police officers are out there doing? Just policing for profit. That's the narrative that is out there, and it's not true. You do not have to have an attorney if you want to talk to a prosecutor or fight a case. All the time, when we serve somebody, this is one of the due process protections, just like in anything. When you're an owner and possessor of contraband, we have to serve you with process, okay? And on that sheet tells you exactly what to do. On that sheet is my phone number, the address, the clerk's address. All you gotta do is make a phone call. Call us up, okay? We bring in people all the time. You do not have to have an attorney to do that. And if they do, that's fine. If they don't, that's fine. I mean, what we're supposed to be doing is upholding the truth and justice. So that's you know what we're trying to do here.
Just if I would jump in just here to talk about the incentive. In our reporting in Kentucky, one thing that some people that pay attention to this have mentioned in that because in Kentucky the police and the prosecutors, they split the money. 85% goes to law enforcement, 15% goes to prosecutors. And some people who have talked about changing the system have mentioned, well, let's change the way we distribute the funds, right? I mean, would there be any interest to, have you all heard maybe here in Texas or elsewhere, sending the money to a school district or to a general fund? Or
you would see that the seizures drop.
I mean, there's no evidence of that because we haven't done that. But I mean, is that something that has any support? I mean, is that something that a prosecutor's office would support?
Well, and yes, that has come up as well. Here's my view on that, is that the money is given to the local district attorney and law enforcement. To me, those local people know where the money is best used, okay? What the problems are in that county. In my county, in Harris County, 4th largest city in the United States, those problems are going to be much different from a county up in the Panhandle, okay? So the local officials know better how to spend that money than sending it, up to, the state or whatever to do with what they will. Let me tell you about Harris County and what we are spending our forfeiture funds on, okay? We believe that crime shouldn't pay, and asset forfeiture funds should be, drug money should be fiscal and social restitution. So what we are doing is we are reinvesting this forfeiture fund back into the community where crime has been a problem, okay? We are making sure that we are investing some of our forfeiture funds into gang prevention programs, to providing counselors for children that are in the schools so they don't enter into gang activity. Also for drug rehabilitation. I mean, I said, you know, most of our cases are from drug cases, from drug dealers that are ravaging our neighborhoods, our communities, you know, indoctrinating our children into gangs. So we want to make sure that our money is going to drug rehabilitation programs as well. So, you know, I don't see how in a society we can say that crime can pay, and that's what asset forfeiture does. It's just one cog in the criminal justice system.
So that I would like to talk about some of the legislative efforts that there have been over the last several years. I know, and you mentioned there was a set of changes that happened to the law in 2011 after some, you know, abuses that were brought up in the system. And Representative Canales, can you talk about some of the forfeiture proposals that have come up in recent years and why you think they're needed? Specific, like the big one, like the far end would be to require a criminal conviction in order to seize this, but there are other things that have been happening as well.
Yeah, so thank you. One of the problems that this civil asset forfeiture poses is the standard of proof, which is a preponderance of the evidence. And for a layman, I will tell you, what does that mean? I would say, look at the scales of justice, drop a feather on one side. That's all it takes to win. And so one of the proposals has been, at least make it clear and convincing. You know, we've heard a lot about law enforcement and what they do with the money. The reality is, as United States citizens, we've got rights. And one of the most important rights is a property right. And to be free of unreasonable searches and seizures under the Fourth Amendment. And so when you ask yourself, what does that mean? Well, that should mean that you can't take my property, seize it, or keep it from me unreasonably. Well, unreasonable to me would mean a preponderance standard, the lowest standard to take your property. So one of the propositions was, you need to at least raise it to the middle standard, which is clear and convincing. I think that's absolutely reasonable. It's not a criminal conviction, which is beyond a reasonable doubt. It's in the middle. It's the same standard they use with children in the best interest of the children. Another standard we've seen is loser pays. That actually, if the state seizes your property and you've got to hire a lawyer and you've got to go pay all the impoundment fees and you've got to pay whatever it took because they charge you storage fees, and you go to trial and you win, then the state has to reimburse you for your lawyer and the storage fees for your car. At this point, you can go to trial and win, and you get nothing back other than your property. You don't get your storage fees for a car in that instance. You don't get your lawyer's fees. You don't get anything. And so there's no disincentive for law enforcement to do that. There's been a number of discovery rules and stuff like that have been proposed. But those are some of the large ones that we've seen, is saying, look, let's at least give a level playing field with the standard of evidence, the standard of proof, and if you're victorious or you prevail on your merits, at least be made whole, because that's what the judicial system is about, is equity and being made whole. And it doesn't seem equitable, it doesn't seem judicious, it doesn't seem American to be able to take somebody's property and then make them lose money to get it back when you did it unlawfully.
If I may address the burden of proof.
Sure.
Okay. There's two different things going on here, okay? There is, what we're determining is, in an asset forfeiture case, what the nature of the contraband is, or the money that was seized. Say it's a drug dealer and it's money that's seized. So we are deciding, and we're trying to determine the nature of that money. Is it contraband? Is it not? Okay, and then another thing that's going on is we have the individual that's been charged with a criminal crime. It's been charged with drug dealing, possession with intent to deliver, whatever, okay? So when we deal with the money side, it's by preponderance of the evidence. It's not the lowest standard. The lowest standard is reasonable suspicion, okay? Preponderance of the evidence is the same level that any kind of money case.
But in a courtroom, it is the lowest standard.
In any kind of money case in a civil proceeding goes through. Okay, so it's preponderance of the evidence. And to have the same burden of proof of taking a child from a parent with clear and convincing, than taking drug money from a drug dealer, it just doesn't make sense to me. I mean, clear and convincing, what Representative Canales is talking about, I mean, that's taking a child from a parent. We're not talking about somebody's liberty. We're talking about contraband drug money that should not be able to exist in this world, right? You should not be able to have anybody profit from their crime. I mean, it's just like contraband, you know, you shouldn't be able to have child porn or bazookas either, right? You should not be able to have contraband. It just can't exist. So I think we have that burden because it's a money deal and because it's important that we not let people profit from their crimes.
I just want to respond because one of the things you keep hearing is it's drug money. No, it's not just alleged drug money. It's houses, it's cars, it's boats, it's jewelry. It's not just drug money. And so to take somebody's home, here's another thing that you asked me earlier, what have I seen? Let me tell you what I've seen. I've seen the prosecutor on more times that I can count say, give us the money, we drop the charges. That happens all the time. And if that wasn't the case, they wouldn't be, that's prima facie evidence. We don't even care you committed a crime. We just want the money. I can put my hand on a Bible, I can show you case after case. That is in their MO. I represented a lady, she was coming from Clayburgh County. She had $3,000. Oh, she must have been a real big cartel member. She was going south for a medical procedure. The officer stops her, asked her if she had any money. She said, I've got $3,000. The car, the money, her were all in jail. She still hadn't gotten all of them back. She lost everything because it wasn't a case that could even be fought. It's not worth $3,000, not to a lawyer, not to her. Most of the stuff that the state wins is by default. And yes, you can say drug money, you can say contraband, but it's not until they prove it. It's not contraband and it's not drug money till they prove it. And what do they have to prove? Hardly anything. They're supposed to have to prove an underlying felony that attaches what's the character of the evidence of the crime. They're supposed to have to prove there's an underlying felony. For instance, you were dealing pot or you were selling cocaine. The way they have to prove that has also been completely dismantled. You don't have to really prove anything. You don't. You have to drop that feather on the side of the scale. And for honest, hardworking Americans that may have a couple $1,000s in their pocket or may have something that the law enforcement, probable cause, and you heard something, and I'm as lightly as possible say it, in a court of law, preponderance of the evidence is the lowest standard. That is the law. Out in the field, yes, probable cause to seize. So it's the two lowest standards. In the United States of America, we use the two lowest standards to take your property. And if we're wrong, so be it. It just doesn't seem fair. It doesn't seem fair that the reporting's loose. It doesn't seem fair that the preponderance of evidence is used. It doesn't seem fair that you don't get your money back. The whole thing is a scam. And if we don't correct it, and if we don't tighten the belts, you're gonna completely continue to see the abuse where, oh, we'll just drop the charges when we're done taking your stuff. It's terrible.
So I'm gonna jump to Jacob. So we could go all day, right? So this is a fairly typical, I think, like an argument that you would see between people who are pushing for reform and law enforcement. Is this something that you see in Kentucky as well? Like, is this kind of a similar?
Yeah, these are two separate interviews that I've had just mashed together right now. Yeah.
So like what you mentioned earlier, like there was some like a proposal that was withdrawn. What has been the conversation in Kentucky? And like if you could maybe jump in, obviously you've been looking at this too, like some of the national things. Like I think now there's about, I want to say 17 states that have required criminal convictions in most forfeiture cases. There's always some exceptions generally, well, not always, but there's usually some exceptions. And this has been, over the last couple years, more and more states have been implementing new laws on how forfeiture is used and how it can be, what can be seized and how it can be forfeited. What has been, how have these changes affected how lawmakers or how law enforcement agencies are looking at this in your state?
Sure, so especially since I think the Supreme Court ruling in, I believe that was November or October of last year with the Timms case out of Indiana. What?
February?
Might have been, was it February?
Not you, because you were, yeah.
Everything blends together, I guess.
Yeah.
But since then, there's definitely been, conversations, and people are, in the courthouse and also in the Capitol, people say, well, things are going to change now. Now there's attention to this issue, so, prosecutors are going to have to maybe have more proof to be able to seize something, or maybe be able to, tie one thing, the property to the alleged crime more clearly. But those are just conversations. I mean, really, like I said, there was just one bill filed last session. There was one bill filed the session prior, and those are focus solely on we want to kind of get a full picture of what is being seized. And it seems like, that's I'm a reporter, so I want information. I want facts from people. And that seems kind of like, we talk about the lowest bar of evidence. That seems like the lowest bar, right? Just tell us what you're taking, right? I mean, I know, District Attorney, you talk about that's a burden on law enforcement agencies. Well, I see it as law enforcement agencies, I think pretty generally, they keep more stats than any other agency, right? Then we know what, you look at an arrest citation, there's a lot of information there. If they're keeping their books, they have to understand how much money they have coming in. So it just seems like, ideally, it's a spreadsheet that is searchable and is provided. But that doesn't, there is pushback just on that, and there's agencies that just don't even follow the statute that we already have. So in Kentucky, yes, there's conversations, but there's not much action on it. Other states, I know that Michigan, I believe there's efforts to limit the amount that can be seized civilly. So law enforcement agencies can, they can't seize, there's like a low bar, so they can't seize underneath that bar, which I think is interesting. I don't know how that would play in Kentucky, and I certainly don't know how that would play here in Texas.
Well, just to give some information, in our report we found that, so we looked at 4 counties from 2016, and we found that half of the cases were for under $3,000.
Sure.
The seizures.
Yeah, and we see that in Kentucky. I'm working on a story right now about how the Louisville Metro Police Department, which is our state's, Louisville is Kentucky's big city, and how they seize, and yeah, many are under $3,000. There's a couple hundred. The low is $33 was seized. That person was not convicted of trafficking. He was charged with trafficking. That charge was amended down to a possession charge for several grams of methamphetamine, and so that raises questions that if the prosecutor doesn't have the evidence to convict someone of trafficking, then why do they believe that those are proceeds from trafficking? Can they prove that those are proceeds from trafficking? These are all the questions that we have when we report these stories. So yeah, I mean, so yeah, it's a deep web that we get into, I guess.
Go ahead.
If I may address the lower amounts.
Sure.
In any organization, you have all levels of personnel, correct? You have your bottom level all the way up to the CEO, CFO, whatever. Same thing for drug trafficking organizations. You have the street level dealers, and to me, those dealers are the ones that make the most impact on our neighborhoods, our communities, because they're on the corner slinging dope. That's what our kids see. They're there, flashing all their money and their bling bling and not having to work a legitimate job over there at the Burger King for it. Okay, so if you say lower amounts, oh, those aren't related to the cartel. Well, they are. They are, because the cartels cannot operate without those street level dealers bringing in that money at the street level, going to mid-level, and then going back down to the cartel down south. Like to also maybe talk about criminal convictions.
Sure. So in our study, again, we found that so we looked at 560 cases. 40% did not have a related criminal conviction to the underlying criminal activity as to why the property was seized.
Okay, so there are good and very valid reasons why a criminal case or a criminal conviction might not be associated with the asset forfeiture proceeding. Okay, I can give you one very good example. Okay, we have a problem. One of the cogs in the wheel of a cartel are the couriers, right? The money couriers, the people that take that drug money back down south to the cartels. Okay. Say, and this is an actual case we had $1.2 million that was being taken back down to the cartel in a truck. All right, the truck driver just picked up the load and was taking it down. Now, there was a larger federal investigation that was going on that had been surveilling this drug trafficking organization. They knew that this was drug money. All the truck driver did was take it, transport it. It was stopped. We knew that money was contraband. It was drug money. Are we going to charge the truck driver? Is that right? why are we going to charge them with a crime, and why are we going to go after a conviction? I mean, if you require a criminal conviction to be in the statute, that money could not be seized, okay? Other reasons, maybe the defendant enters into a diversion program, okay? You know?
And I think some of the proposals for legislation that have been offered have had exceptions made for those types, like a diversion program or a deferred adjudication, where there have been, in the proposals I've seen, it seems like there's been talk about like making some exemptions.
So what if, you know, the individual is arrested, say they're dealing marijuana, okay? They have individually wrapped packages of marijuana. Maybe they admit that the money is from dealing marijuana, okay? But they also have a gun, and the person is a felon, all right? We are going to charge that person with felon in possession of a weapon. It may not be one of the enumerated offenses under Chapter 59, but we're not going to charge them with a lesser charge of possession of marijuana, right? So if you say, I've got to charge them with that charge of possession of marijuana, okay, but it's a charging decision, a more efficient charging decision to charge them with the higher charge. It's not related to maybe you know, the forfeiture statute, but there's not going to be a conviction for a related criminal charge. Is that what we want? No. So there are good and valid reasons why there might not be a criminal conviction. Say the defendant pleads guilty to one offense that he picked up later that's not related, but then in a plea bargain agreement, the other case is dismissed. That doesn't mean the money's not contraband, but it just means that there was a plea bargain agreement in the criminal case. So the legislature, I think, realized that there are good and valid reasons why there might not be a related criminal charge, a charge initially, or a criminal conviction.
Real quick, and then
it's also a good and valid reason why somebody would relinquish real legal money because they're going to get a better deal. Something that's not contraband, that was an unrelated charge, you just heard it. Oh, so they plead to another case, but then all of a sudden that money's contraband. That's also a real valid reason why somebody would relinquish their legally earned money so that they don't suffer a criminal conviction on something else.
If they're doing
it's
that,
a bargaining chip. It's used all the time.
It's unethical if a prosecutor is doing that.
Well, I can tell you there's a lot of unethical prosecutors.
Okay,
so
ours are separate, totally separate.
Okay, so last question before we move to audience questions. You know, you mentioned the Timms case. So there was a recent Supreme Court ruling on forfeiture. There's been some questions as to like how, if at all, that affects states like Texas or Kentucky. Can you just, like, three of you, just very briefly, like, think what, in this environment, in this changing environment that's happening right now, what does the future of forfeiture look like here in Texas and in Kentucky?
I would say in Kentucky, it looks, you know, we're just at the ground level of any types of reform or change or transparency. So I hope that the future, from a reporter standpoint, we just have more information. We have more law enforcement officers that are willing to talk about this. You know, just trying to talk about how, you know, police officers and law enforcement agencies, they haven't done a good job of stating the case. Well, I hope that we have more that are willing to discuss this. I hope that we see fewer going to prison, because that's happened in Kentucky as well. I hope that, you know, the money is being taken, if it's being taken in the right way. Because I've talked to a lot of people. I know the $1.2 million in the truck, it's an anecdote, but we see that, we don't see millions of dollars seized in Kentucky. We see hundreds of dollars, thousands of dollars seized from people that, you know, aren't clearly connected to a cartel. We see a lot of people that are users or addicts that have their money taken. I've talked to prosecutors who are working as prosecutors and defense attorneys who have worked as prosecutors. And there's a saying that the money is either all good or all bad. And if you can't prove all the money is good, then all the money is bad, and you're going to lose it all. And I hope that the future at least has some clear lines about what is taken and what is not taken.
Just wanted to mention, you know, these anecdotes. These are not anecdotes. These are things I've lived. Jim Wells County, I represented somebody where they got half the money and we got half the money. How is that? How is that? You start to settle cases now. It's like settling a car accident. Oh, you take half, we'll take half. You realize, is all the money good? Is it all bad? Who knows? Who knows? Because we don't know. It's not about that. It's about the money. Money walks, and that's the way it rolls.
So what do you think the future for
the
Texas
future?
looks
The
like?
future for Texas, I would dream that we would have reporting requirements that actually show the transparency that Texans deserve. I believe, and I sincerely believe, the standard of evidence should be higher. I will agree with the state and their representative here in Houston that a criminal conviction may not always be necessary, but I believe that in most cases it should. We need to create where there's exceptions to that process. The standard of when you've put in all your hard-earned money and you win your case, it shouldn't be a windfall for the state where they just get to go out and collect people's property, and if you win, they don't have any liability. There should be liability for the state for wrongfully prosecuting these cases. I think that there needs to be reform across the board. The fact of the matter is the Constitution is the controlling document in this country, and the Fourth Amendment, I think, is I'll say this in closing, is that all these people that are Second Amendment lovers, be careful, because the Fourth Amendment doesn't really protect you, because they'll come and get your guns too. So it's just a matter of time before it's somebody that you know that they take their property and it's just not worth fighting for it anymore. The future of asset forfeiture in Texas, I can't tell you is uncertain, but I can tell you what I can see right now is that tomorrow's still bleak. It's bleak.
And there's someone from defending. And if you have questions, if you can grab Charlie real quick while letting you have your last say.
We don't seize and forfeit guns. Just want to let you know that. I believe that as written and as reformed, Chapter 59 is a powerful tool that does protect. It has numerous due process protections written within the statute. I would hope that we would be able to keep and use this powerful tool that we have against the powerful drug dealers, cartel. We're always willing to listen. I'm all for transparency, and I would hope that law enforcement would do a better job at combating the false narrative that is out there. It's just, we just haven't done a good job. So I'm hoping, as reformed, that we get to, keep this valuable and powerful statute.
Okay. First question. Just want to preface, we have about 10 minutes. That went a little long. Make sure your questions prompt and a question. Sometimes we get some comments.
You're starting to come toward my question, which is, we've heard the extremes of what can be the worst and what can be the worst. If you both could come together for the next legislative session, where do you see commonality to go forward so that both your sides have that sense of less extremity, where it's either this or it's that? So where could you two work together on something?
And we're always willing to do that. I'm thinking reporting requirements. I think transparency is always good. I have no problem, and nobody should have a problem. Any law enforcement agency should be able to work closely with anybody that's asking for our stats and to be transparent. So I'm thinking that's one thing that we probably come together on.
I would agree. I think that's the starting place. Transparency in all aspects of government is the starting place. And I think that this is a place where transparency is warranted. It's something it's imperative so that we can actually, we stop talking about anecdotes. Let's talk about numbers.
And I think that in Kentucky, we've seen people from both sides of the aisle begin to come together, at least on reporting and transparency. That's one thing that's kind of binding the political scene.
A couple of statistical questions. One, what percentage of the forfeitures in Harris County are drug-related, A? And then B, if I understood correctly, if something's seized from me, I'm going to get arrested for something, A. And then B, I'm going to get some kind of certificate or something that says I can call you if I think it's unfair. What percentage of those unfair calls they go, oh, you're right, and get returned without them having to go to court to get it?
Okay. As far as drug cases percentage, I'm going to say a large percentage, probably 80% of our forfeiture cases are drug related. As far as your other question about what you're talking about is a citation. We have to give notice to anybody we think is an interest holder or possessor of that property. Okay, so you get handed that. Okay, and it tells you exactly what to do. It has my phone number on it, my name on it. So in Harris County anyway. So that's what you're talking about there. Now, if in any organization, there's going to be mistakes. There's going to just be bad judgment calls. So what we have in Harris County is the officers on the street, if they want to seize contraband, they have to call us up. We're on call 24/7. We have to talk to them. We have to make sure they're abiding to the law, with the law. Then it comes across my desk again. I get to look at it again to make sure that we are not taking innocent people's property. That's the last thing we want to do. Then if it goes, gets filed, then if you can call me, we are always willing to look at anything that you have that says that money's legitimate, okay? I'm always open to that because the last thing I want to do is seize any innocent owner's property. I do not want to do that. So we bring people in all the time without attorneys, with attorneys. We're open to listen. Again, a small percentage. I don't have that exact figure for you, but I mean, the second we see that maybe, yes, it is legitimate, maybe it's not, but and it's not uncalled for us to get false documentation, right? So we want to make sure. So I would say a small percentage. I'm only going to less than 5%. I don't know. I can't put a number on it.
Our report showed it was about 4% of the cases that got everything back. But I do want to clarify that you're not necessarily most of the time you're arrested, but not all the time are you arrested after a seizure. 20% of the cases that we found, there was no criminal charge.
Was that 20%?
No charge.
Oh, no, well, I disagree with that. I think we have a disagreement on what.
For the 4 counties, not
either
just for Harris.
Related or not related.
Right.
So it's how you phrase.
Related to the underlying activity that
I wanted to mention something real quick before you're out of time. The state had talked about that, there's this innocent truck driver, somebody put some money in the truck, somebody put some drugs in the truck. Every time I've ever seen that situation, they take the truck too. They may not charge the guy, but they take the truck too. And so if he was so innocent and you didn't charge him, why take the truck? I just wanted to mention that. I see that 90%, if it's an 18-wheeler, if it's a truck, even if they didn't charge the guy, they take the truck too.
We didn't in that instance.
I think there's a couple other people with questions, so yeah.
Okay. You sort of, I guess, addressed some of this, but on the one hand, we have these anecdotes about how everybody's a drug dealer. On the other hand, we have anecdotes that this is someone just going to do normal business and gets caught up in something. I guess what I wonder, and especially directed towards the district attorney here, is it your contention that this system is working extremely well or even perfectly? Because that's kind of what I'm hearing is that it's basically just it's a public affairs problem. It's a misrepresentation.
It is
but
not.
There's a lot of concerns obviously out there, and I guess what I wonder is whether are these tactics that that you're sort of bringing up helping here, in the sense that when you say that anybody who criticizes this is criticizing police officers, I don't think anybody's criticizing police officers. Well,
that's I guess a rhetoric that you hear, but it is not working perfectly. No, it is not. I mean, with the estimate is $69 billion of drug money goes back to the cartels every year. And if you'll look at the stats with the Attorney General I think it's 2017, only 50 million of that was seized. Less than 1%. Uh-huh.
Citizen concern.
Mm-hmm.
So the way that this is being applied, do you think that there's any problems with the application that their concerns are, correct?
Just to say on the microphone for the people back, he's saying the concerns for the citizen, for Texas citizens.
Basically, are we sacrificing citizens' rights at the expense of trying to fight the cartel?
Well, like I said, there are numerous due process protections, civil liberty protections that are built into Chapter 59 as it stands. It's not perfect, never will be perfect, but for the average citizen, what I would say is probably, this overriding concern is coming from this false narrative that is out there. Can you believe that they can seize your property and not even charge you with a crime? That's one of them, okay? Yes. In certain instances, in good and valid reasons and instances, yes, you can. And that was written into the statute because the legislators had the foresight at that time to know that every time you're not going to charge that person.
Wait, Representative Canales, I'm going to let you respond, and then one more question.
We said, though, there's a bunch of due process built in. I don't necessarily agree with that, but what I can tell you is the deck is stacked. The deck is stacked, and the law enforcement has more rights than you do when it comes to your property. That's the bottom line.
Arif Panju, Institute for Justice.
Hi.
As much as I appreciate the shade, I'm just going to have a brief comment and a question. The comment is that a unanimous Supreme Court in Timbs, we represented Tyson Timbs in February, and several members of the Texas Supreme Court did not think that LLE and Tyson Timbs were mere anecdotes or that what we were advancing in court was a false narrative. In fact, their characterization of forfeiture, both nationally and here in Texas, are at odds with yours, Ms. Beaver. And so that's why we fight for forfeiture reform and for constitutional rights. The question is this. It appears that you're now embracing transparency. You're all, quote, all for transparency, which is great. My question, though, is 4 sessions ago, there was a transparency bill that would have merely asked law enforcement for reporting on the use of forfeiture, not what you spend money on, but on the use. Is there a conviction? Is there an arrest? How much was the property? And I believe your testimony there was that this bill would, quote, end forfeiture, and that Houston's PD relies for its equipment budget on forfeiture to a significant degree. And so these two things are at odds. Are you saying now that you'd be for a transparency bill are you for a transparency bill 4 sessions later now that would require law enforcement to simply identify the property, how much it was, if there was a conviction and an arrest?
You said 4 sessions ago?
Yes.
Okay. Yeah, I wasn't testifying at that point.
It wasn't Ms. Beavers, but there was someone from Harris County who did say that, but it wasn't Ms. Beavers.
No, like I said, I'm all for transparency. And when we're talking about this Timbs case, I mean, it really did not change anything in Texas. It was an excessive fines case. We have followed that doctrine since 2003 when a great case named Bajakajian applied the excessive fines clause to Texas. So it didn't change anything with us. It just made it uniform throughout the United States. We've always taken into consideration Timbs. But as far as transparency, all for it.
There we go. Now we have something to look forward to in 2021.
I'm drafting a bill already.
All right. Well, thank you for our panelists for coming. Thank all of them. And thank you guys for coming.
Thank you, Jolie.
Yeah.